All right, may it please the court. I'm David Missouri of Rayful LLC for the appellant. Your Honors, this is an appeal from a determination by the lower court after entry of a post-judgment, after entry of the final judgment of dissolution where entitlement was already determined. We then had a hearing onto the reasonable amount of fees that was entered by Judge McGowan on November 1 of 2019, and that's what's on appeal today.
Judge McGowan was not the trial judge, as I recall correctly, because I believe I was on the first panel. Judge Atkinson wrote.
That's exactly right. In fact, this hearing occurred about a year and a half after entry of the final judgment. The first point that we make on appeal is that there is no determination and indication in the judgment for the fees of the amount of hours that the court determined was reasonable. Under the decisions of this court, the lower court's failure to identify the precise hourly rate and precise number of hours reasonably expended constitutes an abuse of discretion and renders the order facially erroneous and must be reversed. And what the court did do was say, after the party stipulated to the reasonableness of the rates of the trial attorney, and that's largely what we're speaking about here, was Mr. Long, who was the trial attorney through the entry of judgment. What he did after acknowledging the rates were acceptable, then decided that a reduction of the amount that was being sought, which originally was $179,000 and change, should be reduced by 50%. Right? It's spoken of at page 13 as 50% of the attorney's hours, but there is no calculation of what the hours are, what the total hours are, and I'll tell you why that's not the same thing. First of all, the sum that the court came up with after that 50% reduction is simply just half of what the amount that was asked for in the original order. That's not necessarily a calculation as to what the reasonable hours were, because first of all, you don't have the number of hours. Second of all, you've got 5 different attorneys and 1 paralegal, between them having 4 different rates that they charged. So by essentially giving us a 50% haircut without making a determination as to which of the entries were concerned as unreasonable, were duplicative, were unnecessary, can't be deduced by this court. And that's the reason why it's considered facially erroneous and an abusive discretion as a matter of course when that calculation isn't there, because under cases like Elliott from the 50 CA, it prevents you all in your appellate capacity from making a meaningful review of just which hours were and weren't excluded. So in this instance, we believe it should be reversed as to the first argument, simply because there is no finding of the reasonable number of hours that were expended as part of the calculation. Our second basis is that there is no substantial evidence supporting the reduction that was entered, 50% reduction that was entered. Now, there's a broad discretion that is granted towards a trial judge for making these determinations. It's the one that sees it, experienced it, or at least had review and saw the evidence that was presented during the hearing itself. In this instance, and I'm reluctant to make these types of arguments because of that threshold, but in this instance, and hopefully I have put it forth in succinctly and in detail at the same time, just how abysmal the evidence that supported this finding was, how contrary it was to the actual evidence in the record, how much it was a production of a best case scenario draft of the proposed order that was entered verbatim by the court, and it can't stand. I can't go through all of these bases because they do touch and concern every component, every theme that was created, every instance of assertion of unnecessariness is contradicted both by the testimony as well as just looking at the history of the case itself in terms of the quantum of issues that were not limited to what this court and the appellee argued, which was that most of the attorney time incurred by the former wife's attorneys was unnecessary because it was spent on parenting issues. All right. The evidence that supported the termination as cited in the order itself when you go to those citations, in some instances, they don't actually include the issue of the statements that were cited for, or they are indeterminate. But in every instance, they are nothing more than the appellee himself, the former husband, giving you his opinion of what it was like. And in his opinion, 99% of this case involved children's issues. And
Well, didn't the judge specific, let me ask you, can you hear me okay? Didn't the judge specifically find the husband to be credible and really the wife was not credible? So everything she said was discounted by the court.
Sure. He found, as according to the order, he found his testimony credible. But none of his testimony is objective. It's actually a recollection of what his experience in the trial was. He even said on the trial, in that same on cross, that I believe that the docket would actually be a better indication of what happened in this case than my memory. And he knew he's an attorney, right? But if you look at the objective evidence, not this opinion evidence of the disgruntled former husband, you look at the objective evidence in terms of everything that was filed by these two parties, the intensity with which these multiple issues unrelated to children and parenting were litigated, and other facts such as how could our expert who spent 761 hours on issues get his entire bill paid along those hours, while 593 of the attorneys were somehow half of that being spent on children's issues.
Well, let me ask you a question. Did your expert, was your expert involved with the signature verification process? Because that was ultimately conceded by the wife, contested and then conceded. What expert are you referring to? On
No, I'm sorry,
distribution?
the CPA who had to do the valuations, who had to do the assessment.
And that related to assets that were later
Absolutely.
determined to be premarital, correct?
That it depends, some were premarital, some were marital. We had the CPA who did the entire analysis of all of the assets, non-assets, marital assets for the purposes of the.
So you're saying the expert should have gotten a haircut also in that?
No, the expert should not have gotten a haircut because all of what.
Well, the expert didn't get a haircut. You're saying only the attorneys did.
Exactly. So how could you have the CPA doing 761 hours of work on issues as he testified, which were about the equitable distribution?
So either the judge messed up and should have given the expert a haircut, or the judge shouldn't have given the attorneys a haircut.
Right. The point I'm making is that the findings in the opinion aren't related in any way, shape, or form to what the actual evidence was that was presented.
When you said the findings in the opinion, are you referring to the opinion Atkinson wrote or the final judgment that the court wrote?
The final judgment that the court
Okay, thank you.
So in the next argument that we make has to do again with one of the major themes that the court found. I'm sorry, I'll be back up. Going to H3 and 4, when the court is making its conclusions of law, it states that the reduction justification in this instance is based in part also upon the assets received in equitable distribution. Now, our argument, and it cites a 4th and a 5th DCA case, our argument here is this is essentially a return to the issue of entitlement, which was already determined, right, in the final judgment by the trial judge, Judge Foster. We're only doing a reasonable amount. That's this determination that's being made. And to go into...
Well, I don't want to interrupt you constantly. I do have a question. The word entitlement and the word amount are not used interchangeably under the case law.
Exactly.
You can agree or not contest entitlement, but yet amount is always on the table because of the Rosen factors under Chapter 61. You can say, well, there was litigiousness unnecessary in this case, and that would reduce the amount. Doesn't affect entitlement, but that's what the amount is. Now, you could argue in reverse. Well, okay, well, that's the same way of reducing entitlement, but really you can't reduce entitlement. It's all or nothing. You're either entitled to fees or you're not, but you're not then entitled to get paid for unnecessary labor that the client caused. I think that's what the judge was doing.
That's absolutely right. But in this instance, the issue I'm taking is another basis for the court's ruling was essentially the need and ability to pay of the two parties. That's an entitlement issue. That doesn't get revisited.
And before you leave that, since you raised it, the fact that this took 1.5 years, 2 years after the other case for the attorney fee issue to come to a head, was there anything done in the opinion that reversed equitable distribution among other things that would change your argument here today?
Well, we did have, as you apparently know, a decision that came down from you all with respect to a equitable distribution, reversing a significant amount of the money that had originally been awarded to my client, the appellant, the former
Was
wife.
it 8 to 5 mil?
I'm sorry?
Was it from 8 million to 5?
It
I'm trying to remember
was
the,
from,
never mind.
it was more
Taking
like
you a
4
few.
million, 4 million to, if you're talking about an appellate decision that happened while this determination.
I think there was a rehearing granted. And I think it did address equitable distribution, but it's been a while and I thought I read it, but
Right, right.
I'll check my
One
memory.
reason I asked that question was because you didn't file a motion to amend the brief based upon the original opinion in this case, the substance of the issue. And now you're saying equitable distribution got reversed in large part, let's say $3.5 million. Therefore, are you saying you're entitled to have the issue of fee reduction revisited because need and ability to pay is usually the primary factor in determining amount, not just entitlement?
Well,
And
you know, my
didn't
argument
brief
would
it, but are
be,
you making an argument today?
my argument today would be need and ability to pay is not a basis for making a determination of the amount. It's about entitlement. That would be my, I can read 61 for you, 61.16, which says the court may from time to time, after considering the financial resources of both parties, order a party to pay a reasonable amount for attorney's fees, suit money, and the cost of the other party of maintaining or defending any proceeding under this chapter. And we have cases such as Brady and Shields out of the second DCA that says you make it, if you determine to make a entitlement in the first instance, and then the court reserves jurisdiction to make an amount, you are not, the need and ability to pay determination has already been made. So when you're going into the reasonable amount, you can use the other row factors, the other to some degree Rosen factors,
Okay.
but need and ability to pay because you've made that determination.
So just to cap it off, because I want to understand this, to me, this was a little bit important. Your argument that the amount of the fees reduced in this case was not related to the decision rendered in the first appeal.
Exactly.
Okay,
Yeah.
That's why you didn't amend the brief, and that's
Right.
why you're not saying
Right.
what I was maybe assuming you might be saying. Okay,
No,
thank you.
Understood.
Thank you very much.
I was just saying one of the bases for reducing it in this hearing and resulting in this order, based on the idea of going back and looking at the assets my client got. What does my client have to do? Does she really need this much and how much? That was determined. That's an entitlement. The reasonableness, you get down to the other factors, but not now reanalyzing what is actually needed by my client. And I would say too, the idea that the analysis that was done, even if that were appropriate in this order, followed case law, which I don't think is controlling in this DCA. Second DCA looks at need and ability to pay from a relative standpoint, not as a can that person pay regardless of what we have in terms of the differentiation between the two parties in income. In this instance, the final judgment found that the husband had 3 times more income than the wife, my client, and therefore rendered entitlement. There's no reason to go back to it now and go, well, you know, she's got this much, that should render enough in terms of investment income, interest, and that's another reason we should be cutting off 50% of it. That's my argument with respect to that. The final argument we have, I believe that we have 2 really, the intertwined expenses associated with a matter that was related to the divorce and the domestic strife. Again, in the order itself, the court said only fees incurred in the divorce are recoverable. So all fees incurred, including the civil action on the notes to the father, the former husband's father, is not included. We had made and tried to proffer down below the evidence that was going to support the argument that the notes action that was brought by the former husband's father, which were a large part of the assets at issue in the case itself, was brought during the divorce. And the interaction between the civil counsel that was hired to defend that case, as well as the existing trial lawyer in the marital case to consult with them, that was an intertwined, a related matter and should have been considered for compensable attorney's fees to the extent that those were actually related in that fashion. The court did not cite any case law in determining that because this was not in the divorce case itself, that fees weren't compensable under 61.16. And our argument is that that's not the law. The law is that it can be under these circumstances. And so as a matter of law, the court misapplied the appropriate standard and should be reversed and reconsidered under the basis of whether there is an intertwined relationship between this father's notes matter and the divorce. The last issue, Your Honors, is just a prejudgment interest that was failed, that the lower court didn't award. I believe Pelley's counsel has conceded that that was there and should be reversed on that basis. That's all I have, unless you have some questions for me.
Thank you.
Okay. All righty. Let me stop the clock, clear it. Attorney Hall, you may proceed.
Thank you. Good morning. Cynthia Hall of Severian Hall, PA, representing the appellee David Street. We've been the trial counsel. We've been involved in this case from start to finish, including all appeals. I want to start with the first argument made here.
Forgive me, but I'm going to interrupt your presentation before I lose my train of thought. Happens as you get older. As I look at the final judgment, there's a paragraph that has, I guess it's H, 3 little I's. The court finds that the wife is entitled to payment of 50% of the total and cites Von Baloo out of the 4th, which I think is a Judge Gross decision. There was nothing in that opinion that I could find that related to the imposition of a percentage cut. So I would have to assume that that case was cited for the proposition of what flows in the need and ability that the court discusses in paragraph 4. But what I'm concerned about is, where does the trial court attain the authority to select a percentage figure as compared to the case law that suggests you have to make a reasonable determination of hours? There seems to be a different analytical approach. How do I look at whether a trial judge is reasonable by saying 50% or 49% or 65%, as compared that these were the hours expended? In our district, we require an expert testimony usually that says, I've practiced in this area and I think a reasonable number is. Sometimes opposing counsel will say, Judge, this was the number of hours I expended. And there's some factual basis where you would measure the argument and then say, okay, I find a reasonable range is between X and Y, and I'm going to do it, as compared to saying 50%, 51%, 48%. How do we review that? I'm concerned about the numerics.
I hear you, Your Honor, and I agree that that case does not deal with that issue, and we have not found a case that deals directly on point with that specific issue. But I think we have to look at this 15-page judgment as a whole. And I think there's a couple of questions that Judge Volante asked that I think helps clarify this. If we look at the different types of fees that were billed and requested in this case, there's a breakdown. With regard to the accountants and the experts, they have their role in the case. They tend to work relatively independent. They do their discovery work up their reports, and they come in and testify. What's different about the experts from the attorneys is the attorneys handle all the other issues. The presentation of the trial of the experts' testimony and evidence, but also all of the issues related to this family. So I think that all the testimony and evidence that was presented gave Judge McGowan a good understanding, including being referred to the trial transcript, including being referred to the docket, hearing the credible testimony of David Street, the testimony of Mark Silverio, who was involved in the case from the beginning, and determined that half the time, at a minimum, was spent on overzealous litigation on children's issues, domestic violence issues, hand-holding, civil litigation, all of those issues, and then did the deductions. And I think that where counsel argues we don't have all the factors to do the calculations, they are in that paragraph that you referenced, Judge Castanueva, in H. If you take the total number of hours, the rates were all stipulated to as being reasonable, and then get into subparagraph 3, where it gets into, it does say 50%. You do the math, the balance is there. So maybe that mathematical formula, one line is missing. So
Well,
there's
the
nothing that
concern
says-
I have is that the trial judge heard evidence and would make a finding. He said, would say, I find that there was excessive hand-holding, et cetera, whatever. A reasonable quantum of hours to be expended in this case would be a range of X to Y. And based on the evidence before me, I select this number. Here, my concern is passing on this. We are perhaps allowing a trial judge to arbitrarily select a percentage figure that could be acted as a penalty as compared to determining what a reasonable amount of hours is. Doesn't appear to be any debate about the hourly rate. So the only question we have here, and our standard of review is there competent substantial evidence to support that? Here he selects a number, and I don't know how many hours he ascribes to hand-holding. Now, maybe he will tell me in parts of it that there was block timing or something that prohibited, but there's a review here that we normally customarily go through. And that's my concern, whether this number, where was it selected from?
Well, you know, the judge did get the opportunity to review the billing statements in addition to hearing all of the testimony, and made specific findings here that because of the manner of the narratives, block billing, and many, I mean, too many, I haven't counted them, entries where it says telephone call with client, email with client, follow up with client, all of those entries without enough detail. And counsel for the former wife is not able to break it down either. So the judge looked at it. If, you know, we asked him to look at the docket, we asked him to look at the trial transcript, and our client testified, Mr. Silverio testified about various motions, and he made a determination that
But not the trial court in his order said, I looked at the time slips,
he
found
attached
that there was no notations for these services, therefore I can't attribute it to anything, and I'm not going to award any fees. Lawyer, keep your time slips. I mean, I had an attorney fee case as a trial judge, and I complimented the law firm for allowing their associate a whole half an hour that day to go to the bathroom because they billed 23.6 hours that day. You know, so, you know, you take a look at it. I mean, that's what we do as trial judges. You know, Judge Lonnie and I both sat in domestics. You know, we've been there, and I understand the concern here and the frustration, but I'm also concerned about our ability to perform our function of review.
Well, I mean, the judge said what he did.
Well, let me ask you a question, because there's something in here that I think might illuminate part of the difficulty with analyzing hours. The judge specifically said a substantial amount of the wife's attorney fees were on issues that should not be paid by the husband. Now, when I look at that, substantial to me means more than half, but yet you didn't file a cross appeal. You accepted the 1/2 haircut. You didn't push for more. And if we remand this case to say define substantial, is it 50%? It could be, well, it's really 80%, but I was trying to get rid of this case for 50%. So both sides are taking, or it could be less. Let's say this, well, to me, substantial is 14%. We don't know what would happen on a remand, but we could make matters worse, or we could give someone a grounds for improvement. You're both still disputing what that means without using the word substantial. But to me, that is a tip-off. What does that mean? Then the court goes on to define what it means by what you can't get and how do we get to this 50%. So is it arbitrary, or is it defined but loose lips sink ships type of analysis? It could have been more detailed, but then again, it could get better, it could get worse. Both sides would be taking a risk if we wanted to get this fine-tuned to be perfectly precise using proper words. I don't know that we can accomplish that.
And to add to that, too, the former husband in the submissions to the court suggested that the attorney's fees already paid to the wife during the pendency of the case would have been sufficient to present this case. It was not, despite the fact of what the appellant argues, this was not really a complicated case at all.
Well, that's what the judge found. The judge found it's not complicated.
And it wasn't. He's correct. If you look at the issues, that's why the experts come in and testify as to appraisals and values. The judge picked the data valuation. Not much attorney work necessary there.
Well, a percentage is easier to do than cutting out amounts. But if you looked at amounts related to issues that were ultimately conceded that the judge found were totally unnecessary, like the premarital, like the postmarital, like the signatures, various things like marital assets, you might get more than the 50% reduction.
Well, you could, and if you do the math, the only missing step on the formula would be that he found 232 hours, basically, and 54 hours of paralegal time to be reasonable. The mathematical calculation's not there, but the starting position, the percentage, and then the dollar amount are there.
So you put the hours in as the numerator, do the part of the order that says 50%, the denominator is 2, and you have, according, if I understand your argument, a finding of numbers.
Correct, Your Honor. And we also have the dollar amount. So the dollar amount is specifically stated, so it's all there except for the mathematical formula or calculation being put down all on paper, all the rough notes. So, you know, this is an abusive discretion standard. Judge McGowan was not the trial attorney, or trial judge, but he certainly was the judge on this case for a long period of time. He was well aware of who the parties were. This was a 2-day hearing. He saw the billing records. You know, the former husband should not be penalized for the fact that the former wife's attorney billed in this manner and could not break it down. The former wife didn't even testify on these issues, really. She testified that she had a need for attorney's fees, but she did not rebut the former husband's testimony. This was a case that was litigated primarily unnecessarily on children's issues, where the former wife fought tooth and nail through the entire litigation to minimize the former husband's time with the children. And the end result was that the former husband was awarded a 50% timeshare when we got down to it. With regard to the civil litigation, another big issue that's raised in this brief, the court had already entertained a motion to consolidate the civil litigation brought by Nicholas Street and had declined to consolidate the cases. That litigation was dismissed right before the trial started. The record indicates that the former wife complained that she needed more time to work up her case on the notes, and there was a delay from the 3rd day of trial in February to the last day of trial in June of that year for the former wife to do her due diligence. And at that time, she admitted that the notes were marital assets. So the trial judge in a divorce case, they're not that intertwined. The trial judge has a mandate to identify all assets and liabilities and to put values on those assets and liabilities. The court does not come in and determine whether or not a liability is later enforceable, doesn't rule on the third party's rights or obligations. And an analogy that I drew before to the court, and I draw here again today, is if there's an American Express debt owned by the parties during the marriage, it's a marital debt, it has a dollar amount, the court assigns 50% of that debt to each party, but does not have to take the next step and determine whether or not American Express can collect that debt. In this particular case, there were notes signed by the wife. She thought about it, but she eventually acknowledged it. Handwriting expert had to be called in, but she acknowledged that these were marital liabilities. And Judge Foster went even further in this final judgment and sort of protected the wife because she kept raising this issue and said, if you want to fight that battle on the enforceability of the notes, you can do so. And if you prevail, you can come back. But the civil litigation had nothing to do with this divorce. And Judge McGowan properly declined to award any fees on the civil action. And the former wife always has the recourse to go into the civil case to seek any fees that she believes she's entitled to. You know, the court has absolutely broad discretion here. The court had the testimony they found credible of the former husband, of Mark Silverio, the docket, the list of motions that were brought related to the children's issues. The judge felt that 50% of the litigation was unnecessary for all the reasons stated: domestic violence, unrelated claims, hand-holding, excessive litigation regarding the children. He identified all of those and made, there are 2 separate paragraphs in this final judgment explaining why he gave, as Mr. Hazuri says, a haircut to the fees here. There's no prohibition on him stating that it's 50%. We can calculate the number of hours. That's how the court decided to draft this final judgment. The judge actually put that percentage in himself. And there's so much broad discretion here. And unless there's an abuse of discretion, it stands. We did concede the issue of interest. We think that that was an error, and we think that's easily rectified. We ask that this court affirm the final judgment with the exception of that issue, which we acknowledge was error, with a remand instruction to calculate what that interest amount is. Thank you.
You have rebuttal left, Mr. Hazuri, right?
Yes, sir.
He does. The judge keeps picking up implements that will not write today. My pen just went
That
out.
was a fly swatter.
I think I'm going to call it a day and come back another time and see if I can load up with new pens and pencils. I'm so sorry, Mr. Hazuri, but
No worries.
I like to take my notes. Okay, I think we're ready to go. You did not use all your time, so you have 4 minutes remaining.
Thank you. The reason 50% is a problem, beyond it being a violation of what I believe is the clear case law of this district and others who have decided on it, is that after we put our evidence in as to the fees, both by testimony of the attorneys themselves, the CPA, and the billing records, nothing was done to attack any of the individual billing items. It was all testimony by the appellee himself as to themes that, again, are completely contradicted by the record, as I've laid it out. That being said, there was nothing for the court, unless it did it on its own accord after the fact, to make a determination as to which of the billing records were hand-holding, which of the billing records were block billing, which of the billing records had to do with the uncompensatable matter of children's fees after a certain amount of litigation in that matter. And that wasn't entered into evidence. So unless the court did its own analysis after the fact and came up at a 50% just because it noticed the number of hours was about 50%, this is a primary example of an arbitrary determination by a judge who was not didn't preside over the trial and wasn't presented with evidence that's specified. And this would have been the appellee's obligation under Sentex. You've got to specify now, after the evidence has been put in carrying a prima facie case of the reasonableness, as to what you're talking about in terms of what is unreasonable. And Your Honors, if you tried to do it now, you wouldn't be able to, in terms of finding this 50%. We do want to go back, because if we do believe, when we get the court to look at the actual entries, to consider what we've raised in terms of what was actually litigated and the time that was spent on it, that we will get more than 50. So that's the sum and substance of my rebuttal. And thank you all very much.
Very
Thank
nice.
you. Thank you both.
Thank you both.
Stay well. Have a good holiday.